for?
I am. So did I show you the picture who I ran into on the plane?
No.
President Clinton. And Hillary on the plane.
Right.
Yeah, it's pretty funny.
We're live now.
Okay.
I'll show you the picture.
All right, John, you ready to go? Yes, okay, call to order. We go here, I guess, okay, for assessing the city, we'll note the items you called this morning. Who did? Jasmine and Nick is, he's on travel this week, so he's away. Well, we have enough. Yes, sir. Quorum is present. We don't need a roll call. Okay, I assume everybody read the minutes a few times, just to make sure that we're all, are there any comments on the minutes? If not, I would ask for a vote to accept the minutes of February 13th.
Second.
All in favor?
Aye.
Thank you. Kevin, you're on.
Mr. Chairman, in the sake of expedience, because a few of our members are on a little bit of a short leash, I will forego my presentation. And Amy, do you have anything that has been?
Not at this time.
No, so I'd go right on so you can get to the voting before anybody has to leave.
Your, both of your reports?
Yes, well, there is a couple of items I have to discuss in executive session that relate to some real estate negotiations.
Okay, then, sir, no, sir. Yes, sir. So there's, we're gonna move on, as the vice chair just said, to item number 5 on the agenda, which is the St. Rose project. We have 3 resolutions, and I want to make sure the secret resolution is first, so I'm not sure if that's noted here or not. I know that was the last change. Should say secret resolution first, and then bond resolution second. Okay, because we're going to take our secret action first. Joe, do you want to walk through secret? Would you like me to? And I know you're remote, however you want to do it.
It's up to you, Tom. I'm more than happy to talk about it, or you could start and I can
Great,
fill
thanks,
in.
Joe. I'll do this and stand by for the bond.
Okay.
Transaction. So the first resolution that I'll review, and if the board would so consider, we would recommend that it would pass this resolution, and it's titled Secret Resolution. I'm going to walk very quickly through the whereas clauses. First whereas clause talks about our authority creation, how we're going to be created. Second talks about our mission. The third talks about our powers to acquire, construct the St. Rose facilities and project. And third, and one of the main topics of this particular meeting is to issue negotiable bonds to finance the cost of such project. As you work down the second page, you'll see that the initial project, what we're calling the initial project, that's a defined term, is several main items. It's the acquisition of the property that we're about to discuss today. It's the acquisition of certain equipment. It's the financing of all or a portion of those costs for the land and the equipment. And then the payment of the cost incidental to the issuance of the bonds, which will enable us to purchase both the property and the equipment. The rest of these whereas clauses tell the story to how we got here today. It starts with the bankruptcy that was filed by St. Rose. It talks about our actions in December, where we passed both a secret resolution at that time as well, and then authorized the submission of a bid pursuant to the bidding procedures that the bankruptcy court had authorized. We, as all of you know, were the successful bidder on that. That walks you through sort of those occurrences. As I said, in December, there was a secret portion of that. There was a secret determination that the submission of a bid and entering into a purchase and sale agreement was an unlisted action with no significant impact to the environment. And that will be discussed and ratified again today as we move into these other actions. So again, it continues to tell the story. Today, the actions include the acquisition and the issuance of the bonds, in addition to certain post-closing actions, which will involve entering into a post-occupancy license that will enable the staff of the College of St. Rose to maintain some presence here on the campus as they wind up their operations pursuant to the bankruptcy court. It will allow for the acquisition of certain personal property that the college has. and then allow the entering of service, utility, property management contracts that are now, as we become a property owner, we need to enter into to ensure the prudent operation of our property. And then finally, insurance. Now that we're going to, again, be a property owner to obtain proper insurance coverage. So that is the action, both the acquisition bond and all of those post-closing actions that we are looking for, that is deemed to be the capital A action in the secret resolution. And again, very similar to what we did in December, we find that this is a unlisted, it is not a type 1 action, and therefore it doesn't need what's called a coordinated review, and we are able on our own to make the take the review and make the determination. And that's what you find here. So I'll just turn very quickly to the now the whereas, beyond the whereas clause into the resolution clauses. So basically what it says is based on the examination of the action, the board finds that the initial project consists of the items that we just talked about, and then the post-closing actions include the things that we just talked about once we acquire the real estate, and that the acquisition alone and those post-closing actions will not commit us to any certain path. And so therefore, a segmented review is proper in this instance because we don't know what the development action or proposals would be. This is simply just an acquisition of the property at this point, and any subsequent actions that we would make would be subject to further secret review and the normal planning process to the extent that it's applicable to our public authority. Okay, so that's what this says. Again, it talks about it being unlisted action and that the action based on our review results in no major impacts and therefore does not cause significant damage to the environment. And Kevin has prepared a negative declaration which is attached to it, and you'll be adopting that negative declaration that contains the findings that I've just run through. I'm trying to be brief, a brief summary. I don't want to take away, I don't mean to change anything that's in the resolution. What is in the resolution stands, regardless of what Tom Owens says today, but that's an overview. Yes, sir.
Just for those who haven't been through this process before, explain why the environmental issue has to come into play in a transaction like this.
Yes, sir. So anytime a government entity takes a discretionary action, it is required to basically comply with the environmental conservation law. And provisions of that require the agency and or government entity that is taking that action to take certain steps to review the potential environmental impacts of whatever that agency's action is. So that's what we're doing here. And before you take those actions, you have to put that review and your determination on the record. So that's what we're doing here.
And if you don't do it, then the subsequent actions are annulled. So it's standard fare for any governmental authority.
I'm aware of it. I just wondered if everybody else was.
Yeah. So subject to that, if we could, if the board would so choose, I'd like to try to get a first and a second.
First, a second.
Ms. Reginelli, Ms. Walsh.
Any further discussion? Any
Further discussion about the seeker approval?
No.
If not, I would ask for a vote. Raise your hands if it's yes. Any opposed? Thank you.
Great.
That's good. Thank you.
Yes, sir. So that's the secret resolution. That's the first resolution we're going to be dealt with now, and we're going to move on now to Mr. Scott and the bond resolution. Joe?
Thank you, Mr. Owens. So the bond resolution, as Tom indicated, is the second resolution for consideration. And as was discussed, it's very important for the authority to do their secret finding before taking any final action with respect to a project. And the bond resolution is, in fact, the final action that we'll be taking with respect to the financing. It authorizes, at a 50,000 foot level, it authorizes the issuance of the bonds and the entering into the documents by the authority. Let's turn to the resolution. I'm going to not talk about the whereas paragraphs, which I indicated earlier in the Finance Committee meeting is the story with respect to the project. And as Tom went through them in connection with the seeker resolution, it includes the description of the project and a description of how we got to where we got to today. So if you get to the operating, or if you turn to the operative provisions of the resolution And I'm going to start with section 1 and quickly run through and give you a summary of the operative terms of the resolution. Section 1 ratifies the prior actions by the authority. As you well know, we've adopted a number of resolutions during the process of our consideration of the project. And what we're doing in section 1 is ratifying and confirming and approving those resolutions. Section 2, we make several findings with respect to the project. And what that does is lay a basis for what we're doing. The project is a project as defined under the authority's governing statute, and we make that finding in section 2. And again, highlighting this liability issue, if you look at section 2D as in dog, again, there's language there making clear that the board members and the county and the city and the state are not directly obligated under the bond issue, other than obviously the financing agreement that we've been talking about. And then in section 2E as in Edward, there's language in that section about the finance committee making a recommendation to the full board. So it connects the dots, if you will, with respect to our process of reviewing the matter. Section 3 describes all the various steps that we're taking with respect to the financing, the issuance of the bonds, the execution of various documents, including the financing agreement with the county, the operations and maintenance agreement with the county, tax documents to provide the basis for the tax exempt status of the bonds, and certain filings and recordings that we need to do in connection with the transaction. Section 4 authorizes the officers to approve and execute the documents. Section 5 formally approves and authorizes the issuance of the bond. And as Tom indicated in the title of the Finance Committee resolution, the principal amount of the bonds is an amount not to exceed $41 million. The numbers are being refined and honed down today, and we would expect that they'll be just over $40 million, but under the $41 million cap in the resolution. The balance of the resolution, for instance, section 6 authorizes the officers to execute the documents. Section 7 authorizes additional actions. And then section 8 makes clear that the resolution, unlike some resolutions in connection with the issuance of debt in New York State, this resolution is effective immediately. There's no waiting period. There's no publication periods. There's no additional approvals other than the approval that Eric has indicated and described during his presentation, the approvals by the New York State Comptroller and the Albany County Comptroller. But this resolution is effective immediately, and we can move forward with the issuance of the bonds. The parties authorized are the chair, the vice chair, and the CEO to sign the documents, and we'll also need the secretary to attest to their signatures on a couple of documents. And with that, I'll open it up for any comments or questions. Thank you.
Comments, questions? Guess we all understood that then. I guess we'll move on.
We can do it first and second if the board would so choose.
Okay, I guess we want to adopt this resolution. Ask for a motion. In favor?
I'll first.
Okay, second? Got 2 seconds. Okay, this is third. All in favor, raise your hand, please.
Aye.
Any dissenters? Don't see any. Resolution is passed.
Okay, Mr. Chair, Vice Chair, I'll take the third potential resolution for the board to consider to move forward on it. And this we've talked about briefly already. I'm not going to go through all the whereas clauses. It's the same whereas clauses. This authorizes 4 post-closing acquisitions, which is,
If I could interrupt you, there is one individual here who you may not have met before, Paul Goldman, with Paul Goldman LLC is representing us in the closing, and is here to answer any questions that may come up in that regard. Sorry.
Yeah, I think everyone else-
Paul. I think everybody knows Paul.
Now, right.
What excuses? All right, 4 items that this resolution would authorize the CEO to negotiate and potentially enter into. But you're giving him the authorization, as well as the chair and vice chair. There's 3 individuals in here that can sign these documents if they proceed to a point that they're going to be executed. One is a potential post-occupancy agreement for the College of St. Rose. The second is a potential acquisition of the St. Rose personal property. The third is entering into contracts that would involve the maintenance, management, operation, utilities of the property once we own it. And fourth is to obtain and procure proper insurance coverage as a property owner to do that. We're now shifting into the property ownership phase of disabilities lifetime. So the only thing I'm going to point out is because of the type of transaction in St. Rose, there is certain information in the resolution that has to be public and made known to the board, and I've laid that out here. It talks about the space. It's up to a certain amount of office and storage space. It's all laid out in the resolution. It talks about an appraisal that was done that found value for the real property. It talks about the consideration, which is none for the College of St. Rose, and it talks about the benefits to the authority to do something like this, to have the former operator here for a period of time, to give that knowledge transfer, to give that situational awareness to the property that we will be learning over the next certain period of time. This gives them the ability to stay here through the 30th of June, but they've indicated that much of this space will be vacated prior to the 30th, probably next month or May, as they move out. And so this is really just to enable them to basically wind down their operations. And that's the extent of it. I don't want to spend any more time on the written word, but it's all there, and I'll entertain any questions.
There are no monetary pieces of this at this point. There are.
Well, we are gonna authorize Kevin to negotiate it. We are gonna certainly try to get at least some what I would call the utility charge / operating expense. That would be a set number per month that they would pay us to offray at least the building costs, so to speak, from a utility perspective, John. That would be part of that agreement. But the agreement is not final yet, it's still being negotiated, and we're authorizing Kevin to negotiate and then potentially execute.
Okay, any questions about that resolution, that transaction? If not, I'll ask for a vote. Go ahead first. Second? Okay, thank you. Raise your hand, all in favor? Any dissenters? Well, that's easy, 3 in a row. Sure. I think, if there's any other business before we go into the executive session?
Yes, sir. So the reason for the executive session today, we need a first and a second, is to discuss the potential sale or disposition or acquisition of real estate, the publicity of which would significantly affect the value thereof. And then also it will be to seek and obtain legal counsel from your attorneys. So those are the 2 reasons we would be exiting the open session.
Okay, well then, given that direction, I would ask that we adjourn this public hearing, and shortly thereafter, we will commence the executive session.
Yes, sir. And if we could just get a first and second, and we'll vote, then that'll be the formal adjournment.
Okay, first, second, to adjourn the open session, second, all in favor?
Aye.
Okay, thank you. We move into executive session.
Members of the public, feel free to grab a couple